Well, lots of questions for employers to start asking. Yesterday, it was here on this program that we heard that the Emergency Services Coordinator, Grant Stevens, announced that from midnight last night, an end to the vaccine mandates in schools and also in passenger transport. That follows the end to the vaccine mandate for SAPOL, for our police force. He also foreshadowed that at the end of the Emergency Management Act that is in place at the moment, and that could be within 20 to 8 days, we are likely to see vaccine mandates end at the end of that. Well, we will see them end whenever that act ends, and it's likely to be in 28 days. So these are sort of questions that many employers are going to have to start thinking about now in terms of the issues they need to consider without that banner of a vaccine mandate. This morning, some of the difficulties were laid bare when Carolyn Granskans from the Australian Independent Schools Association, she's their Chief Executive Officer, spoke to David, Stacey and Nikolai. Now, she said the vaccine mandate had taken the issue out of their hands previously. They're going to be meeting tomorrow to consider the implications of its removal.
Well, there are laws that you have to follow in terms of being an employer. This has to be defensible should someone take the decision to the Fair Work Commission. There's a whole process that has to be gone through. Employers can't just decide that they're going to mandate a vaccine at a school level.
Are you saying some independent schools might like to have a vaccine mandate, but they can't impose that without...
Well, they can't they can't just impose it. No. They have to consult.
Yeah. And if they did go down that path, they could find themselves in an industrial tribunal.
Well, none of our schools would do something that was against the industrial law. The industrial law that they operate under requires consultation.
Might be a bit fuzzy what you can and can't do.
It's not as straightforward as it might seem.
All right. Well, is it as complicated as Carolyn suggests there? Margaret Kaukas is a Special Counsel in Workplace and Industrial Law at Anderson Solicitors. Margaret, good afternoon.
Good afternoon, Sonya.
Is it that difficult to consider some of the issues around these changes?
Well, it certainly isn't straightforward. I think a lot of people, particularly those who oppose the idea of being required to vaccinate, might think that the removal of this mandate means it's fine, you don't have to be vaccinated at work, and it is certainly not that simple. Employers may still decide, notwithstanding the removal of the mandate or the lifting of the mandate, that in their circumstances it is appropriate to have a policy requiring mandatory vaccination. I think what the speaker who we just heard from was saying was that, the Fair Work Commission has found previously in a case involving BHP that such policies can be imposed, but it is critical that there be appropriate consultation with the workforce before any such policy is put in place.
Because it's not simply a vacuum, isn't it, where you bring in people who previously have been excluded. There's a whole lot of people who are still there who may also have issue with that change.
Absolutely, yes, absolutely. And I think for employers who have a policy in place, and leaving aside, of course, those employers, in the public sector, in schools and public transport, and, of course, police, where the mandate has been lifted, there are still many employers who have a policy in place requiring their staff to undergo vaccination. And as long as that policy was introduced appropriately, with appropriate consultation, the question will then be whether their direction to staff pursuant to that policy is lawful and reasonable. And I would think that in many circumstances, notwithstanding the change to the mandate, the Fair Work Commission may well still conclude that direction to be vaccinated is lawful and reasonable, and therefore a refusal to comply justifies dismissal.
Can you explain some of the factors that an employer is now going to have to sit down and consider? Some of the barriers to that. When you look at making a decision on this, is it enough to say, look, we've looked at this and this is how we're dealing with it, or can you make a blanket recommendation to, for instance, impose a workplace direction of a similar kind of mandate that is applied more broadly up until now?
Yes, well, I suppose the overriding factors are, first of all, what your previous speaker was talking about, and that is consultation. So whatever workforce-wide policy is introduced, there must be appropriate consultation with the workforce before that's introduced. Now, that means talking to the workforce, getting their views, explaining what the policy involves, etc. That's the first thing. The second thing is when attempting to impose that policy, you've introduced a policy, we require everyone to be vaccinated, you say to your staff, this policy is in force, we require you to comply. There has to be appropriate flexibility to take into account circumstances which might fall outside of the norm. And there has to be an appropriate time frame and indeed consultation about the application of the policy. But in terms of the substance of the policy, the sort of factors and the overriding factor, I think, in this circumstance is the employer's obligation pursuant to work health and safety legislation. So regardless of what the state government does, every employer in Australia has an obligation to, so far as reasonably practicable, ensure the health and safety of their staff, and not just their staff, but any other people who enter the workforce. Now, in the recent case involving a policy which BHP attempted to introduce in a mine, the Fair Work Commission ultimately struck down that policy, but it was on the basis that there was not appropriate consultation. The Fair Work Commission had said otherwise, there would have been, if there had been appropriate consultation, they would have upheld the policy. And what they talked about were a range of factors, including the fact that even with high vaccine rates in the community, they formed the view that COVID remained a significant hazard in any workplace if there's people interacting with
Now,
each
Margaret,
other.
I'm sorry to interrupt you, but we're having real trouble with your phone going in and out at different volumes. Now, I don't know if that's you moving around or whether it's the quality of the phone line. Is it worth us trying to get another phone line for you?
No, I think it's my Italian hands waving around.
Oh, okay.
I'll try to hold the phone steady.
No, that's fantastic. Margaret, so does that rule out then the option of an employer simply doing nothing? And by that I mean just kind of continuing on as normal and saying, well, we want it in place, let's leave it, or let's not do anything. Let's just say you've got your freedom of choice. You can choose whether you're vaccinated or not and just allow that to happen. Or are they breaching some form of duty of care there?
Okay, well, if they already have a policy in place and it's been introduced appropriately, as long as when they apply that policy they do it properly, so they allow for any circumstances where someone may, for some legitimate reason, not be able to be vaccinated, then I don't think this changes the situation, the situation with the state government mandates being lifted. In terms of doing nothing, well, the risk there is that if someone does become infected by COVID, there can certainly be an assertion made by that person that the employer has breached their obligations under the Work Health and Safety Act by not doing all that's reasonably practicable to protect them in the workplace. So I think it would be very dangerous for the employer not to consider this issue. I mean, if the employer considers it and says, well, we don't want to compel our staff to be vaccinated, you would expect that they would be using some other control measures to attempt to manage that risk, the risk of infection. And we all know that the latest variation is still spreading through the community. Things have died down, thank goodness, but there is still a significant risk of anyone moving through the community of contracting COVID. And even if they don't get it themselves, they may give it to their grandmother who's elderly or whatever.
So Margaret, these are things that every employer, although this at the moment only affects SAPOL, schools and passenger transport, with the view that eventually vaccine mandates will end when the Emergency Management Act ends, are these things employers should be starting to consider now?
Absolutely. I mean, I think all employers should have been considering this quite apart from the mandates. This is an issue, a live issue for the community, and employers are part of the community. And work is a large part of our lives. So, yes, just as any other potential risk to the health and safety of their workers, employers should be addressing this and considering it.
It's 21 minutes past 1 here on ABC Radio Adelaide. We've got with us Margaret Kaukas from Anderson Solicitors. She's a special counsel in workplace and industrial law. Now, you may have some particular questions to throw her way. If you can, ring us now or text through now. That would be great. 0467 922 891. 0467 922 891. Let's try and get some of these questions that may be on your mind about this to her and get some answers. It's 22 minutes past 1.
Wake up to Adelaide's #1 breakfast show.
What a way to start the day.
Hans perform at the Adelaide 500.
Breakfast?
Hans, will you answer that call?
Well, you know, the Labor Party, they have promised an international name. Hello? What we could do is combine it with some of Australia's finest. I'm seeing a night of Barnsey, Fancy and Hansy.
Oh, there we go.
Don't miss breakfast.
Weekdays from 6
on ABC Radio Adelaide.
Spend a perfect afternoon with Sonya Feldoff. On ABC Radio Adelaide.
We're taking a look at the industrial law implications around the lifting of the vaccine mandate with Margaret Kaukas from Anderson Solicitors. Margaret, in terms of the schools area, just to get a little bit more specific, we know that with some of those teachers who were employed previously who chose not to get a vaccine, some of them may have had to use up leave, long service leave, and then if there was no, if they weren't vaccinated at the end of that, there wasn't a job for them. They would have to go. Where do they sit now in terms of coming back to jobs in teaching? Is there any position for them or any arguments that they could make on that front?
Well, in terms of people who have resigned, sort of from a purely legal perspective, they've resigned and there is nothing that can be done about that, although I would hope that employers in that situation might be willing to be flexible and consider allowing the employee in question to revoke their resignation. For employees whose employment has been terminated, again, under the public sector employees fall under slightly different rules than other employees. So there may be some remedy available to them under the public under the legislation that applies to public sector employees. But generally, you would bring an unfair dismissal claim, but the time limit for that is very short. So in terms of strict legal remedies, their options may be very limited. I would hope in those circumstances, as I said, that employers would apply some flexibility and allow employees who've either resigned or been terminated the opportunity to be reinstated. But legally, their options may be limited.
On the flip side of that, we've had quite a few teachers who were offered year-long contracts because it was presumed that the other staff were unavailable. Are they suddenly, under the changed circumstances, allowed to be disposed of, or are they guaranteed that work according to their contract?
Well, it would depend entirely on the terms of the contract itself. If the contract had a clause that said, if there's a change in these circumstances, the employment can be terminated, then possibly. But otherwise, no, they would be entitled to remain in employment unless there was some other legitimate reason for their termination.
Where do schools sit in this interim period? I mean, that overall mandate was lifted at midnight last night. We know the independent schools, for instance, are meeting tomorrow to consider some of their options around this, and it's not simple. We've got a time in between where there is nothing that covers that situation legally.
Nothing that covers...
Well, the schools,
sorry.
because, the mandate was lifted with no warning, with 8 hours warning, and they haven't had time to put in place alternative plans. This public consultation you've been describing, etc. So where do they stand in terms of that? Because that's going to take a period of time.
It is indeed. Well, if there's no policy in place and there's no other law, such as the emergency laws in place requiring vaccination, then employers can't say to an employee, you must be vaccinated and you can't come to work. They could conceivably, if they're in the process of developing a policy, ask people to go on gardening leave, if you like. They'd have to pay them if they did that while they were developing such a policy. But in the absence of an existing policy in the workplace, and I would have thought most employers would already have one, this is not the first month of the pandemic, but in the absence of such and without a government mandate applicable, well, then there is no basis for an employer to say to an employee, you must be vaccinated and you can't work unless you have been.
This texter takes it out of the schools and is asking about a friend who they say works for a consultancy that mandates vaccination to attend their own office location. However, they placed her with a client that does not have the same policy for vaccination. Can she refuse to work at that client's workplace?
Look, I think if she's concerned about the risk, if, for example, she's at particular risk of a special harm, if she's a vulnerable person, then I think it would be reasonable for her to say, I'm not comfortable working there because, you can't guarantee that appropriate measures have been taken to ensure my health and safety. I think that would be appropriate. Whether or not that person could absolutely refuse without some sort of negotiation might make it more difficult. And of course, again, it falls into the ballpark of employers being reasonable and being willing to talk to their employees and work things out.
Margaret Kaukas, thank you for helping us navigate some of these legal areas around these changes. She's Special Counsel in Workplace and Industrial Law at Anderson's Solicitors.